came along and said, no, I don't think the literal approach can work in all scenarios. I'm going to opt for a different approach. And Attorney General versus Paperlink sees a rejection of the literal approach in favour of a different approach called the purposive approach. Okay, take a look at the quotation here. The Constitution is a political instrument as well as a legal document, and its interpretation, the court should not place the same significance on different languages used in the two subparagraphs as it would be placed on different draft subsections of a Finance Act. Now, what he's saying there in honest to God English is, he's saying that the Constitution is different to legislation. While a literal approach to interpreting legislation might work, the same approach won't necessarily work to the Constitution, because the Constitution, by its nature, is generally worded. It's supposed to be something that can be manipulated and changed to cover different situations and to change over time. However, legislation is detailed. It's specifically written with lots of detail. So, of course, it's much easier to apply a literal interpretation to legislation than it is to the Constitution. The Constitution is intended to be general and not to be detailed. So then he said, in light of that, a purposive rather than a strictly literal approach to the interpretation of subparagraphs in the Constitution is appropriate. Okay, so what he's saying is, don't be looking at the literal words used there and saying, well, what do those words mean in ordinary everyday language? He said, look at the purpose of the Constitution. Why did the drafters put this article in? And then try to arrive at a result in the case that fits the purpose of that provision in the Constitution. Okay? Now, what then happened, the difficulty then you'll see in paragraph 107, and you can read it yourself there at the beginning, is how are you going to find out the purpose of a provision in the Constitution? These were written in 1937. A lot of the provisions were. So the people who drafted the Constitution mightn't be here. They didn't give us a guide with the Constitution that said, when we put in Article 5 calling Ireland a democratic, independent and sovereign state, this was our purpose. So no explanatory memorandum came with the Constitution. So the difficulty, people who don't like the purpose of approach is, they criticise it because they say, how are you going to know what the purpose of a provision is? What are you going to have to do? You're probably going to have to guess. What's the whole idea of constitution interpretation? What's it supposed to keep out? Judicial subjectivity. If you're saying a judge can guess what the purpose behind a provision is, then you're bringing judicial subjectivity straight into interpreting the Constitution. And this is one criticism of the purpose of approach, is that because we haven't a definitive guide to the purpose of each provision in the Constitution, a judge is going to have to speculate as to what the purpose of the provision is, and that is bringing judicial subjectivity into interpreting the Constitution, which is what all these methods are supposed to keep out. Okay? Some people say, well, look to the purpose for history. But that's okay if it deals with an issue that was relevant in 1937. But divorce wasn't around in 1937. So when we're interpreting the divorce provision in the Constitution, how can we use the purpose of approach? Because it wasn't there in 1937. Similarly, if you look at something like marriage, which was there in 1937, but we didn't have a divorce provision. So how does the introduction of divorce impact on the definition of marriage? Then people in 1937 wouldn't have thought about that issue. Okay? So the difficulty, as I said, with the purpose of approach is, okay, it does bring us away from this literal interpretation and allow judges to give a wider interpretation, but it brings back in judicial subjectivity, and you have a difficulty with trying to establish what the purpose is. Okay, now a case that clearly shows us the purpose of approach at play is Quinn Supermarket versus the Attorney General. Now, what was happening in the Quinn Supermarket case was, in this case, we'll take a read of it here in the manual because it explains it perfectly to you. In this case, a ministerial order granted an exemption to Jewish meat shops from restricted opening hours applicable to other butcher shops. Despite the prohibition against religious discrimination in Article 44(2)(3, the court upheld the discrimination as it was necessary in order to allow the free practice of the Jewish religion as guaranteed by Article 44.2. The court looked at the primary purpose of Article 44 and believed that its primary purpose was to allow the free practice and profession of religion. Now, what was happening there was, in that case, you had two provisions within Article 44. One was saying that everybody had to be allowed freely practice their religion. Another was saying that the state wasn't allowed to discriminate on religious grounds. So the state had a dilemma. If they forced Jewish butcher shops to only open the same as other butcher shops, they weren't going to allow the free practice of religion, because the Jewish faith was not going to be able to buy meat in accordance that had been prepared within the time and in accordance with their religion. However, if they granted Jewish meat shops an exemption from the restricted opening hours, they were discriminating in favour of Jewish meat shops and against non-Jewish meat shops. So there was no way out of this. They had to discriminate in order to ensure the free practice of religion. And the judge had to look at the overall purpose of Article 44 and said, really look at what the drafters were trying to do here was ensure the free practice of religion. If it's necessary to discriminate in favour of one religion to allow the free practice of religion, then that's a necessary evil within the Constitution. Okay. Similarly, you'd have the same type of clash within the article that guarantees the right to life of the mother and the unborn. We saw in the X case that you can't honour both of those. At times, a judge may have to opt for the life of the unborn over the life of the mother, and that's, again, a necessary evil within the provision of the Constitution. Does everyone understand? So the Quinn case is our purposive approach at issue. Now, we're going to come to Curtin at the end, in which they talk further about this purposive approach. Okay? Then another method, and this is the more common method, and to me it certainly is the method that works best in the Constitution, is now, don't think that one is bad and one is better. They all have their uses, but they all have their difficulties as well. So often the type of method that's used will be dictated by whatever the judge is being asked to interpret. So if he's been asked to interpret a particular aspect of the Constitution, the literal approach mightn't work. However, the harmonious method may turn out to be the best one for that scenario. So which method is actually used in an individual case will really be dictated by whatever is the issue the judge is being asked to interpret. So the next method which can be used is the harmonious method. Now, what this is doing, and this is a very good method, this harmonious method, we'll take a look at some cases on it here. This harmonious method involves trying to ensure that whenever you interpret a provision in the Constitution, you do so in a way that fits in with all the other provisions in the Constitution. So take, for example, the word election. If you interpret the word election, we'll say in one way under Article 16 to do with all elections, that you make sure that whatever meaning you give it there equally fits in for presidential elections, which is dealt with in Article 13 of the Constitution. So this is what the harmonious method involves doing. It involves trying to make sure that whenever a judge interprets a provision in the Constitution, he makes sure that it fits in with other references to that word or that phrase within the Constitution. Okay? So it does what the name says, harmonious. Now we're going to see a number of cases where this is used. First one here is, look, we're back to DPP versus O'Shea. Remember, the majority in that case favoured the literal interpretation of the word all. However, the dissenting judge in the case, and your dissenting judge is the judge who doesn't agree with the majority, the dissenting judge, Henchy J., dissented on the basis of using the harmonious method. So what did he say? He said, and this is very important, any single constitutional right or power is but a component in the ensemble of interconnected and interacting provisions which must be brought into play as part of a larger composition, and which must be given, now this is the important bit, and which must be given such an integrated interpretation as will fit it harmoniously into the general constitutional order. It may be said that the Constitution, more than any other legal document, that the letter killeth but the spirit giveth life. Okay, you can ignore that biblical type reference. So what he's talking about here is that, look at, the Constitution isn't made up of neat little provisions that all fit into a box separate from the others. It's an overall document for the running of a country. They interconnect. So when you have a provision, we'd say, dealing with all elections, underpinning that is that later on in the Constitution you've got a provision which says you're going to treat everybody equally. So while you may focus on the article dealing with all elections, a judge has to bear in mind that there is an overall philosophy under our Constitution of equality in everything, which would mean that in the regulating of all elections, it's not just Article 16 dealing with all elections, equality is also at play. So this is what the dissenting judge